right. Peace. All right, now we officially back in the building. Welcome back to the Universal Temple for the Sun, Planet, Moon, and Stars. I'll be your Lord of Hosts, Lord Messiah, and we're going back into today the Treaty Handbook, and we're going to build on the registration of treaties. So basically, after you develop your treaty, how do you register it? You know what I mean? So I ain't gonna, be long-winded today. Like I said, I'm gonna try to make these videos shorter and shorter, but it's a lot of information, so But we're gonna go straight into that. Ain't gonna waste no time. Let's get it. Yeah. All right. So we go with the registration of treaties. Okay, so I'm gonna play this here. I'm gonna let it play and go in and start breaking it down.
Registering or filing and recording treaties. 5.1 Article 102 of the Charter of the United Nations. See the Repertory of Practice, Article 102, Para. 1. Every treaty and every international agreement, as the present charter comes into force, shall, as soon as possible, be registered with the Secretariat and published by it. 2. No party to any such treaty or international agreement, which has not been registered in accordance with the provisions of paragraph 1 of this article, may invoke the treaty or agreement or any organ of the United Nations. Thus, states members of the United Nations have a legal obligation to register treaties and international agreements with the Secretariat, and the Secretariat is mandated to publish registered treaties and international agreements. Within the Secretariat, the treaty section is responsible for these functions. Registration, not publication, is the prerequisite for a treaty or international agreement.
Right, so part of stuff. So they said states are obligated, saying thus the state members of the United Nations have a legal obligation to register treaties and international agreements. So when you come to international agreement with other nations, or an agreement with other nations, you have to file that, as in a form of an international agreement or a treaty, which is basically an international agreement, with the Secretariat. Who is the Secretariat? The Secretary General. And they send it through the Department of Legal Affairs. Excuse me, the Office of Legal Affairs, and they fine tune comb your documents, go over it, make sure everything is right in this act, and then they go on to register the documents. Now it says here, it says registration, not publication, is the prerequisite for a treaty or international agreement to be capable of being invoked before the International Court of Justice or any other organ of the United Nations. So when you're dealing with them, you have to register your treaty, not necessarily publication. So if you're just doing like a publication on your own, that's just your own publication. Like I say, when you make that publication, that's your responsibility to make that known to the world. Like you just want to go on your own and just make it known to the world. Like I said, we can develop. My bad. I hope y'all was able to hear what I was saying before. But we can develop an international treaty and deposit that or present that treaty to all nations of the world. And whoever wants to accede to that treaty, we can come to an international agreement with them. Doesn't necessarily have to be deposited with the United Nations. You know what I mean? We can have our own separate agreement. But if you're going through them and you want to bring your international agreement before the International Court of Justice and have it actually, backed by international law and international agreements, then, this is the way to do so. You know what I mean? So, yeah, moving on.
Agreement to be capable of being invoked for the International Court of Justice. The objective of Article 102, which can be traced back to Article 18 of the Covenant of the League of Nations, is to ensure that all treaties and international agreements remain in the public domain and thus assist in eliminating secret diplomacy. The Charter of the United Nations was drafted in the aftermath of the Second World War. At that time, secret diplomacy was believed to be a major cause of international instability. 5.2 Regulations to give effect to Article 102. See the Repertory of Practice, Article 102, Para. 2, and the Annex to the General Survey. Recognizing the need for the Secretariat to have uniform guidelines for implementing Article 102, the General Assembly adopted certain regulations to give effect to Article 102. So the regulations. The regulations treat the act of registration and the act of publication as two distinct operations. Parts 1 and 2 of the regulations, Articles 1 to 11, deal with registration and filing and recording. Part 3 of the regulations, Articles 12 to 14, relates to publication. 5.3 Meaning of treaty and international agreement under Article 102. 5.3.1 Role of Secretariat. See the Repertory of Practice, Article 102, Para. 15. When the Secretariat receives instruments for the purpose of registration, the treaty section examines the instruments to determine whether they are capable of being registered. The Secretariat generally respects the view of a party submitting an instrument for registration that, insofar as that party is concerned, the instrument is a treaty or an international agreement within the meaning of Article 102. However, the Secretariat examines each instrument to satisfy itself that it, prima facie, constitutes a treaty. The 26. Registering or filing and recording treaties 5. 27. Secretariat has the discretion to refrain from taking action if, in its view, an instrument submitted for registration does not constitute a treaty or an international agreement, or does not meet all the requirements for registration stipulated by the regulations. See Section 5.6.
Right. So basically, like I say the Secretariat has discretion to refrain from taking action, you know what I'm saying, from submitting the instrument if it's not right in exact, basically. If it's not up to the protocols of all the stipulations, the regulations and everything they got to follow, you know, then they won't submit it. So like I said, their job is to make sure everything is up to par. So say if you didn't make it right in exact according to all the protocols, they're going to show you like, well, according to this section, Article 102, you have to do like this or whatever. You have to, you know, make sure this is there. You have to have your declaration, blah, 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 blah. You know, whatever you may have missing or didn't do correctly, they're gonna have you do it correctly before they submit it. So, you know what I mean?
5.6. Where an instrument submitted fails to comply with the requirements under the regulations or is unclear, the Secretariat places it in a pending file. The Secretariat then requests clarification, in writing, from the submitting party.
Right.
The Secretariat will not process the instrument until it receives such clarification.
Right.
Where an instrument is registered with the Secretariat, this does not imply a judgment by the Secretariat of the nature of the instrument, the status of a party, or any similar question. Thus, the Secretariat's acceptance for registration of an instrument does not confer on the instrument the status of a treaty or an international agreement if it does not already possess that status. Similarly, registration does not confer on a party to a treaty or international agreement a status that it would not otherwise have. 5.3.2 Form. See the Repertory of Practice, Article 102, Paras. 18 to 30. The Charter of the United Nations does not define the terms treaty or international agreement. Article 1 of the regulations provides guidance on what comprises a treaty or international agreement by adding the phrase whatever its form and descriptive name. Therefore, the title and form of a document submitted to the Secretariat for registration are less important than its content in determining whether it is a treaty or international agreement. An exchange of notes or letters, a protocol, an accord, a memorandum of understanding, and even a unilateral declaration may be registrable under Article 102. 5.3.3 Parties. A treaty or international agreement under Article 102, other than a unilateral declaration, must be concluded between at least two parties possessing treaty-making capacity. Thus, a sovereign state or an international organization with treaty-making capacity can be a party to a treaty or international agreement. Many international organizations established by treaty or international agreement have been specifically or implicitly conferred treaty-making capacity. Similarly, some treaties recognize the treaty-making capacity of certain international organizations, such as the European Community. However, an international entity established by treaty or international agreement may not necessarily have the capacity to conclude treaties. 5.3.4 Intention to create legal obligations under international law. A treaty or international agreement must impose on the parties legal obligations binding under international law, as opposed to mere political commitments. It must be clear on the face of the instrument, whatever its form, that the parties intend to be legally bound under international law. In one instance, the Secretariat concluded that an instrument submitted for registration, which contained a framework for creating an association of parliamentarians, was not registrable under Article 102. Accordingly, the instrument was not registered. 5. Registering or filing and recording treaties. 28. Secretariat determined that the document submitted was not a treaty or international agreement among international juridical persons to create rights and obligations enforceable under international law. 5.4 Type.
So, in other words, your documents, like in other words, so I'm realizing, like my international organization that I develop, like, I can draw it up for myself, but maybe I'd have to get like maybe some declaration or some autograph of approval from, say, like a minister at the Grand Sheik at the of the Moorish Science Temple, saying that they agree to go into the international agreement for my international organization. One of the head ministers of the Nation of Islam and one of the elder gods in the Nation of the Gods of Earth. If those three heads come together and sign this treaty that I draw up, then basically that's what will make it legally binding under international law. And we all agree that basically we're going to come under international law and be bound by international law in the international agreement. That's what will make it official. So I have some more work to do. I got to reach out to some people and make things solidified. So that way I can present a treaty and then it'll be understood that this is an international agreement between the three nations I just mentioned. You know what I'm saying? And like I was mentioning to people, what I'm doing in my international organization, we don't have to take on the teachings or accept the teachings of the other said nations. However, we can utilize those teachings or utilize the bylaws of those said nations in our benefit, and they can use our bylaws in their benefit. And therefore, we come together in a beneficial agreement that we're all going to use each other's bylaws, come together for one common cause to have this international agreement and build as nations to further our nations as well. Then we present the treaty.
Types of registration, filing and recording. 5.4.1 Registration with the Secretariat. See the Repertory of Practice, Article 102, Part 43 to 44, 55 to 57, and 67 to 70, and Article 1 of the Regulations in the Annex to the General Survey. Under Article 102 of the Charter of the United Nations, see Section 5.1, Treaties and international agreements of which at least one party is a member of the United Nations may be registered with the Secretariat, provided that the treaty or international agreement has entered into force between at least two of the parties, and the other requirements for registration are met. Article 1 of the Regulations, see Section 5.6. As mentioned above, members of the United Nations are obliged to register, under Article 102, all treaties and international agreements concluded after the coming into force of the Charter of the United Nations. Thus, the onus to register rests with states members of the United Nations. Although this obligation is mandatory for states members of the United Nations, it does not preclude international organizations with treaty-making capacity, or non- A specialized agency is permitted to register with the Secretariat a treaty or international agreement that is subject to registration in the following cases. Article 4.2 of the Regulations. A, where the constituent instrument of the specialized agency provides for such registration. B, where the treaty or agreement has been registered with the specialized agency pursuant to the terms of its constituent instrument. C, where the specialized agency has been authorized by the treaty or agreement to effect registration. In accordance with Article 1(3) of the regulations, which provides for registration to be effected by any party to a treaty or international agreement, the specialized agency may also register those treaties and international agreements to which it itself is a party.
Peace to Mozzie 38 in the building from my meet me crowd. You know what I'm saying? So yeah, that last paragraph right there was just building on the fact of how, you know, where the treaty or agreement has been registered with a specialized agency. Yeah. You know, basically everything in accordance with the articles, you know, and regulations. Basically, is you have to follow the rules and regulations, basically, of the protocols and all that. To a treaty or international agreement, the specialized agency also register those treaties and international agreements to which itself is a party. So, for example, say you have a bilateral treaty with the state that you're in, then they have a duty to deposit that treaty as well. So when you go into agreement with them, then the state will deposit the treaty as well. You know what I mean? Or whatever agency that it is that you're coming into the international agreement with.
Party. 5 point.
Also, yeah, because you can also you have what's called NGOs, non-governmental organizations, and you have you know, international organizations and so forth. So you have different ways you can connect with different entities and so forth, you know what I mean, to make international agreements.
5.4.2 Filing and recording by the Secretariat. See the Repertory of Practice, Article 102, Paras 71 to 81, and Article 10 of the Regulations in the Annex to the General Survey. The Secretariat files and records treaties or international agreements voluntarily submitted to the Secretariat and not subject to registration under Article 102 of the Charter of the United Nations or the Regulations. The requirements for registration outlined in Section 5.6 in relation to submission of treaties and international agreements for registration apply equally to submission of treaties and international agreements for filing and recording.
Okay, so in other words, they're saying even if you're not doing it, filing a treaty under the regulations of Article 102 of the Charter of the United Nations, they are still required to register, you know, in relation to submission of treaties and international agreements for registration apply equally to the submission of treaties and international agreements, filing and recording. So basically, you know, they're going to file it anyway, you know what I mean? Basically, you know, they have to file, basically.
Registering or filing and recording treaties 5.29. Article 10 of the Regulations provides for the Secretariat to file and record the following categories of treaties and international agreements where they are not subject to registration under Article 102.
So
treaties or international agreements entered into by the United Nations.
So you know, some people say like, yo, we don't have to go do them, or we don't have to do this, that, and third, da 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 da. Okay, well, you still gonna have to go through the Secretary General, you know, the Secretariat to get your documents filed. Like, well, where else you gonna file them? You know what I mean?
Nations or by one or more of the specialized agencies. This covers treaties and international agreements between the United Nations and non-member states. 2. The United Nations and specialized agencies or international organizations. 3. Specialized agencies and non-member states. 4. 2 or more specialized agencies. And v. Specialized agencies and international organizations. Although not expressly provided for in the regulations, it is also the practice of the Secretariat to file and record treaties or international agreements between 2 or more international organizations other than the United Nations or a specialized agency. B. Treaties or international agreements transmitted by a member of the United Nations, which were entered into before the coming into force of the Charter of the United Nations, but which were not included in the treaty series of the League of Nations, and C. Treaties or international agreements transmitted by a party not a member of the United Nations, which were entered into before or after the coming into force of the Charter of the United Nations, and which were not included in the treaty series of the League of Nations. 5.4.3 Ex officio registration by the United Nations. See the Repertory of Practice, Article 102, paras 45 to 54, and Article 4.1 of the regulations in the Annex to the General Survey. Article 4.a of the regulations provides that every treaty or international agreement that is subject to registration and to which the United Nations is a party shall be registered ex officio. Ex officio registration is the act whereby the United Nations unilaterally registers all treaties or international agreements to which it is a party. Although not expressly provided for in the regulations, it is the practice of the Secretariat to register ex officio subsequent actions relating to a treaty or international agreement that the United Nations has previously registered ex officio. Where the Secretary General is the depositary of a multilateral treaty or agreement, the United Nations also registers ex officio the treaty or international agreement and subsequent actions to it after the relevant treaty or international agreement has entered into force. See Article 4(c) of the regulations. 5. Registering or filing and recording treaties. 30. 5.5 Types of agreements registered or filed and recorded. 5.5.1 Multilateral treaties. A multilateral treaty is an international agreement concluded between 3 or more parties, each possessing treaty-making capacity. See Section 5.3.3.
Right. So, the international organization I developed, it's consisting, like I said, it's based upon the philosophy of knowledge of Noble Drew Ali, the philosophy of wisdom of the Honorable Elijah Muhammad, and the philosophy of understanding of the Father Allah, which all leads to the philosophy of culture for the universal temple for the sun, planet, moon, and stars, which is my international organization. So that international organization consists of the philosophies of these 3 nations, of the, the leaders or, teachers or fathers of these 3 nations, which makes it an international organization. And like I say, when I get the approvals, from these said nations, is going to make it an international organization. It's going to make it an international agreement once they all attest to it and all put their autograph and seal and so forth on the document. Once that's done, I can have that document presented or registered, and it's going to be approved. You know what I mean? So that's how I would have to do that right there. You know what I mean? So that's one of the plans that I'm doing, you know what I'm saying? But like I was saying, y'all already know what I've been saying. So let's go.
5.3.3. 5.5.2 Bilateral treaties. The majority of treaties registered pursuant to Article 102 of the Charter of the United Nations are bilateral treaties. A bilateral treaty is an international agreement concluded between 2 parties, each possessing treaty-making capacity. See Section 5.3.3. In some situations, several states or organizations may join together to form one party. There is no standard form for a bilateral treaty. An essential element of a bilateral treaty is that both parties have reached agreement on its content. Accordingly, reservations and declarations are generally inapplicable to bilateral agreements. However, where the parties to a bilateral treaty have made reservations or declarations, or agreed on some other interpretative document, such instrument must be registered together with the treaty submitted for registration under Article 102 of the Charter of the United Nations. See Article 5 of the regulations. 5.5.3 Unilateral Declarations. See the Repertory of Practice, Article 102, para 24. Unilateral declarations that constitute interpretative, optional, or mandatory declarations, see Sections 3.6.1 and 3.6.2, may be registered with the Secretariat by virtue of their relation to a previously or simultaneously registered treaty or international agreement.
So in other words, unilateral declarations that constitute interpretive, optional, or mandatory declarations may be registered with Secretary. So in relation to previous or simultaneous registered treaty or international agreement. So in other words, if there's already a treaty or international agreement that's already in place, and you say, hey, I like this international agreement, I like this treaty, and you know what, I want to accede to this treaty, you can then, form a unilateral declaration or draw up a unilateral declaration saying, yo, just my organization, we want to, accede to this treaty, you know what I'm saying, and so forth. And you'll accede to the treaty or become part of the treaty or international agreement, and you register that. You know what I mean? So, yeah.
Unlike interpretative, optional, and mandatory declarations, some unilateral declarations may be regarded as having the character of international agreements in their own right and are registered as such.
Right.
Example is a unilateral declaration made under Article 36(2) of the Statute of the International Court of Justice, recognizing as compulsory the jurisdiction of the International Court of Justice.
Oh, okay, right. So in other words, when you bring the see how the International Court of Justice works is same way by other courts, but like these lower courts, they try to make it seem like you have to secede, you have to submit to the jurisdiction and so forth and da 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 da. Which you don't have to, you know what I'm saying? But being that we're state property and all of that under the jurisdiction of the state, then they try to force you into contract. But once, like I say, once you develop yourself like an international organization, get yourselves on the international level, international forum, then you're now dealing with international law, which supersedes state law. So the only way that the international court can have jurisdiction over the said parties is if the said parties both agree to give jurisdiction to the court. And basically by you filing or bringing the matter to their court is you giving them jurisdiction over the matter anyway. So, and then also they basically say you have to basically file a declaration stating that, yeah, we give jurisdiction, we give the court jurisdiction, saying da 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 da, and we wish to proceed under international law. You know what I mean? So that's how that works. So they're saying the same thing like with a unilateral declaration. You have to draw a declaration stating that you're gonna accede to this treaty or international agreement, and you're gonna, be bound to, consent to be bound to the international law that is developed under. You know what I mean?
Justice. These declarations are registered ex officio, see Section 5.4.3, when deposited with the Secretary General. A political statement lacking legal content and not expressing an understanding relating to the legal scope of a provision of a treaty or international agreement cannot be registered with the Secretariat. 5.5.4 Subsequent actions, modifications, and agreements. See the Repertory of Practice, Article 102, and Article 2 of the Regulations in the Annex to the General Survey. Subsequent actions affecting a change in the parties to, or the terms, scope, or application of, a treaty or international agreement previously registered can be registered with the Secretariat. For example, such actions may involve ratifications, accessions, prolongations, extensions to territories, or denunciations. In the case of bilateral treaties, it is generally the party responsible for the subsequent action that registers it with the Secretariat. However, any other party to such agreement may assume this role. In the case registering or filing and recording treaties 5.31 of a multilateral treaty or agreement, the entity performing the depository functions usually affects registration of such actions. See Section 5.4.3 in relation to treaties or international agreements deposited with the Secretary General. Where a new instrument modifies the scope or application of a parent agreement, such new instrument must also be registered with the Secretariat. It is clear from Article 2 of the Regulations that for the subsequent treaty or international agreement to be registered, the prior treaty or international agreement to which it relates must first be registered. In order to maintain organizational continuity, the registration number that has been assigned for the registration of the parent treaty or international agreement is also assigned to the subsequent treaty or international agreement. 5.6 Requirements for registration. See the Repertory of Practice, Article 102, and Article 5 of the Regulations in the Annex to the General Survey. An instrument submitted for registration must meet the following general requirements. 1. Treaty or international agreement. Within the meaning of Article 102 as mentioned above, the Secretariat reviews each document submitted for registration to ensure that it falls within the meaning of a treaty or international agreement under Article 102, see Section 5.3. 2. Certifying statement. See the Model Certifying Statement in Annex 7. Article 5 of the Regulations requires that a party or specialized agency registering a treaty or international agreement certify that the text is a true and complete copy thereof and includes all reservations made by parties thereto. The certified copy must include A. The title of the agreement, B. The place and date of conclusion, C. The date and method of entry into force for each party, and D. The authentic languages in which the agreement was drawn up. When reviewing the certifying statement, the Secretariat requires that all enclosures such as protocols, exchanges of notes, authentic texts, annexes, etc., mentioned to the text of the treaty or international agreement as forming a part thereof, are appended to the copy transmitted for registration. The Secretariat.
Right. So in other words, if you say like, if in your treaty you say, okay, yeah, we intend to, you know, adhere to subsection B of Article 2, da 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 da, then you have to have a printout or a copy of Article 2, Section B, whatever, da da da, you know, attached to the treaty. You know what I'm saying? Or, you know what I'm saying, give like a reference to it and so forth. So, or if you give reference to, this is according to the articles of, this is according to the Vienna Conference, you know what I'm saying, Conference of Vienna and so forth, and da da da, you know, you have a copy of that attached to, you know what I'm saying? So whatever you give reference to in your documentation, you have a copy of that attached to the document. And see, now the significance of that is, like, I did a whole breakdown on annex. You know, you could go on my Facebook and look up the title. I think it was called Adhesion Contracts. You know, and I broke down basically about the word annex. You know, then I went into the whole like delivery and so forth, the whole science of the birth certificate and then the hospital and all of that, the doc and the doctor and all of that, and maritime law. But basically, the adhesion contract. So when you annex or attach another document to the original document, that's like a stipulation to the document. So for example, when I applied for my state ID and updated it in my righteous name, I also attached my declaration of name change and declaration of nationality to the, you know, application. So now that declaration becomes an adhesion to the contract, or a new stipulation or a new clause, you could say, to their application. So now by them giving me that card, they didn't give me the card just as a regular person. Hey, I just want to change my name. Hey, da 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 da. Because usually when you do a name change, they want you to have a document from the court. So therefore, when I went to do my name change declaration, all that, I filed it with the, you know, Department of State or whatever. They put their raised seal on it and all that good stuff. So understand, the Department of State, the Secretary of State, that is a court. So you gotta understand that when they talk about, oh, you have to have a document seal from a judge. No, that Department of State is a court. That is a court. So when you go in there, you get your documents authenticated, when you attach your declaration to your birth certificate and so forth, and they put their raised seal on there and it says, oh, this document has full faith and credit of the United States and all that, da da da. That's what makes your thing official, and that's what makes it you know, able for them to accept it, basically. You know what I mean? So yeah, and you know, so them, they ask you to write a certifying statement. The certifying statement is just to say that, like, yeah, everything in this here is it's kind of like a jewel rat, you could say. You know what I'm saying? When you're stating that everything in this documentation is right and exact, is true to the best of my knowledge, you know, belief and so forth and da da da. You know what I mean? So yeah. That's what the certifying statement is.
Secretariat brings the omission of any such enclosures to the attention of the registering party and defers action on the treaty or international agreement until the material is complete. 3. Copy of treaty or international agreement parties must submit 1 certified true and complete copy of all authentic texts and 2 additional copies or 1 electronic copy to the Secretariat for registration purposes. The hard copy versions should be capable of being reproduced in the United Nations Treaty Series. 5. Registering or filing and recording treaties. 32. Further to General Assembly Resolution 53-100, the Secretariat strongly encourages parties to submit, in addition to a certified true copy on paper, an electronic copy, i.e., on computer diskette, CD, or as an attachment by email, of the submitted documentation. This assists greatly in the registration and publication process. The preferred format for a treaty or international agreement submitted on diskette is WordPerfect 6.1 for Windows, as this is the system that is used in the publication of the United Nations Treaty Series.
Y'all heard, in case y'all overlooked that or heard that, they said when you do your electronic form, on a CD, disc, whatever, diskette or whatever, attachment by email, to submit your documentation. They want you to use WordPerfect 6.1 for Windows. You know what I'm saying? So Windows WordPerfect 6.1. That's the exact, model or fonts and everything they want you to use for your documentation. So if you don't have that, I guess you maybe have to download it or maybe go to a computer, public library where they may have that particular, version, and or just download it. Just download it on your computer and then just use that exact version right there. Saying WordPerfect 6.1 for Windows. All right. So, let's continue.
Series. Treaties may also be submitted in Microsoft Word for Windows or as a text file. The generic
part of stuff they said also publications, treaties may also be submitted in Microsoft Word for Windows. So basically, your regular Microsoft Word. You'll see this right here, Word right here. You know what I'm saying? Regular Word. You know what I'm saying? Word documents. You know what I mean? So yeah. All right, let's continue.
ASCII text format for saving documents. The preferred formats for a treaty or international agreement submitted by email are Word, WordPerfect, or Image, TIFF format. All electronic submissions by email should be directed to treaty registration at un.org.
So right there, treaty registration at un.org, UnitedNations.org. So treaty registration at un.org. When you want to register your treaty, you want to send it by email, you send the electronic form in Microsoft Word for Windows, the generic ASC, to or whatever text format, and you send that to the treaty registration at un.org. All right, that's when you send your electronic form, your email form, basically.
Treaty registration at un.org. Member states and international organizations are also reminded of the resolutions of the General Assembly, initially adopted on December 12, 1950, A/RES/482, and most recently repeated on January 21, 2000, A/RES/54/28, urging states to provide English and/or French translations of treaties submitted for registration with the United Nations Secretariat where feasible. Courtesy translations in English and French, or any of the other official languages of the United Nations, greatly assist in the timely and cost-effective publication of the United Nations Treaty Series. For date of entry into force, the documentation submitted must specify the date of entry into force of the treaty or international agreement. A treaty or international agreement will only be registered after it has entered into force.
So basically, the date of entry will be the date that you registered the document or the date that you finalized the international agreement, or the treaty, the day that the treaty was completed and finalized and all agreed upon. You know what I mean? That will be the date of entry or the date that you physically registered it, via the email or sent it off by mail to the Secretariat.
Force. 5. Method of entry into force. The documentation submitted must specify the method of entry into force of the treaty or international.
Right. So in other words, you got to say, okay, I'm sending this via email and we sent it by mail. You know what I'm saying? Registered mail. You know what I mean? To the Secretary General, to the Office of Legal Affairs. So forth, and through email, and you give your information and everything of how you sent it and everything like that. It's kind of like a written pre-receipt. You know what I mean? Receipt.
International agreement. This is normally provided in the text of the treaty or international agreement. 6. Place and date of conclusion. The documentation submitted must specify the place and date of conclusion of the treaty or international agreement.
Right.
This is generally inserted on the.
So you can say, well, at a law school, we had a meeting, and the brother from the sheikh from the Moorish Science Temple and the minister from the Nation of Islam, they came to a law school, and we and the elder gods, we all sat down and we drew up this international agreement. We came to the agreement, we all attested and signed the documentation, so forth and so forth, And not saying that it has to happen at a law school. I just use that as an example. Like, man, you ain't bringing them niggas to a law school now. Say for God, they ain't right about what we about. Understand, we know that. This is what you call an international agreement. You know how they say that term, like agree to disagree? I don't necessarily agree with that terminology, but I'm going to apply that to this in the sense that, like, we can agree to disagree, meaning we don't have to agree upon each other's teachings. We don't have to be in the mosque praying to a mystery Allah. We don't have to be, no disrespect to, what I'm saying, but we don't have to be, in the temple, wearing a fez or whatever the case may be, taking on other customs of other nations and so forth, or speaking a different language or whatever the case may be. We can respect the other customs, respect the other language, respect the other bylaws, adopt them. Not saying we have to implement or practice them, but we can adopt them. You know what I mean? And they can adopt ours, and then we can come to an international agreement that, we're all going to respect each other's customs and so forth, and we're just going to put all our religious beliefs or whatever our beliefs or whatever to the side, and we're going to come together because we're all melanated people, and we have nation building. We have to uplift humanity, and we have to civilize all the human families on the planet Earth. We have a job to do. We have a duty to do. So why not come together and do it together? And however they choose to do it, they do it in a fashion. However they choose to do it in a fashion. However we choose to do it, we do it in our fashion. And we all just getting work done. All that bickering and arguing, brothers want to sit around and argue and debate over this, that, and third, and yada, 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 yada. Where is that getting us? It's not getting us anywhere. So therefore, like Malcolm said, put all that other stuff to the side and come together on this common cause. All right, man, come on, because I'm tired of all the nonsense, and I'm tired of all the, blah, blah, blah. What you doing? Why are you sitting there talking all that separation and how we can't come together? What are you doing? I'm what? What? I'm me, God. I'm the. You ain't doing shit. Anyway, next.
On the last page immediately above the signature, the names of the signatories should be specified unless they are in typed form as part of the signature block. 5.7 Outcome of registration or filing and recording. 5.7.1 Database and record. See the Repertory of Practice, Article 102, and Article 8 of the Regulations in the Annex to the General Survey. The database of instruments registered and the record of instruments filed and recorded are kept in English and French. The database and record contain the following information in respect of each treaty or international agreement. Registering or filing and recording treaties 5. 33. A. Date of receipt of the instrument by the Secretariat of the United Nations. B. Registration number or filing and recording number. C. Title of the instrument. D. Names of the parties. E. Date and place of conclusion. F. Date of entry into force. G. Existence of any attachments, including reservations and declarations. H. Languages in which it was drawn up. I. Name of the party or specialized agency registering the instrument or submitting it for filing and recording. And J. Date of registration or filing and recording.
Right. So all of that A through J is everything that should be mentioned within the documentation, within the international agreement, within the treaty or the declaration, what have you. You know what I mean? All of that, this right here, A through Z, saying the date of receipt, registration, title, name, dates, languages, all that good stuff should be mentioned. All right. And that's what the Office of Legal Affairs are going to do, beforehand. And also, like I said, you can also read the final clauses handbook, because the treaty handbook, what we're going through right now, this teaches you how to do your part on how to make sure you got everything right. But then in the final clauses handbook, that's like the handbook that the Office of Legal Affairs uses to make sure that they do their job right, which is to check your documents, do everything, make sure everything is right, So actually, you can kind of go up ahead a little bit. You could kind of, ain't this so ill? This is like you in college and you like handing in term papers, but if your thing ain't right, they're not going to just give you a failing grade and dismiss you. They're going to correct it and tell you everything you need to do and to make it better. And then you hand it back in and be like, oh, okay, now I got an A. You know what I'm saying? And then they're going to further assist you on. So it's just so ill, man. You know what I mean? So I think that's ill. Like I think that's a lot of help because like shoot, I'm doing a whole lot of work myself, man, just trying to read and study and understand all this stuff and put it all together. And then I gotta draw up the documentation and all of that. So, like I was saying, if you go into the treaty handbook, you can kind of go ahead a little bit and see what their obligations are, so you know exactly if your document's going to be right. Like it's kind of like they telling you what to do, and then you know their rules on how they're going to overlook if you did what you needed to do, right? And is that so? It's like you got two handbooks on how to overlook your documents and make sure it's done right from your perspective of what you need to do and from their perspective of how they need to overlook your documents. You know what I mean? So you can go and overlook it yourself and act like, you know, kind of see it from their position and do their job for them, kind of, and for yourself too, because it's helping you out before you hand your documentation in. So, you know, just trying to say, like, if you want to get that extra insight on it, go into the final clauses handbook. All right, so let's continue this up because it's almost going to an hour and it wasn't supposed to be an hour, but let's go.
Recording. 5.7.2 Date of effective registration. See the Repertory of Practice, Article 102, and Article 6 of the Regulations in the Annex to the General Survey. Under Article 6 of the Regulations, the date the Secretariat of the United Nations receives all the specified information relating to the treaty or international agreement is deemed to be the date of registration. A treaty or international agreement registered ex officio by the United Nations is deemed to be registered on the date on which the treaty or international agreement comes into force between two or more of the parties thereto. However, if the Secretariat receives the treaty or international agreement after the date of its entry into force, the date of registration is the first available date of the month of receipt. In accordance with Article 1 of the Regulations, registration is effected by a party and not by the Secretariat. The Secretariat makes every effort to complete registration on the date of submission. However, due to certain factors including volume of instruments deposited, need for translations, etc., a certain amount.
All right, so basically, like, you have to deposit your document before they can register it. You know what I'm saying? Like, you got to hand it over, and then they got to look over it. Then they're going to say, okay, this need to be right. This needs to be right. Take that back. Okay, fix it up. Okay, you hand it back in. Okay, oh, yeah, everything's good now. Okay, all right, good. You know what I mean? Like that.
Amount of time may elapse between the receipt of a treaty or international agreement and its inscription in the database. Registering parties have an important obligation to ensure that documents submitted for registration are complete and accurate in order to avoid delays in the registration and publication processes. In cases where submissions are incomplete or defective, the date of registration of the treaty or international agreement is deemed to be the date of receipt of all of the required documentation and information, and not the date of the original submission. 5.7.3 Certificate of Registration. See the Repertory of Practice, Article 102, and Article 7 of the Regulations in the Annex to the General Survey. Once a treaty or international agreement is registered, the Secretariat issues to the registering party a certificate of registration signed by the Secretary General or a representative of the Secretary General. Upon request, the Secretariat will provide such a certificate to all signatories and parties to the treaty or international agreement. According to established practice, the Secretariat does not issue certificates of registration. 5. Registering or filing and recording treaties. 34. In respect of treaties or international agreements that are registered ex officio, see Section 5.4.3, or filed and recorded, see Section 5.4.2.
Yeah, so, you know, basically, that's how they do. Like, they have an obligation to do what they do, but they're not going to do it if it's not, right in the act, basically. Now they're going into publication. They went through registration, now they're going to go through publication. After that, I think I'm going to end it off on that because that's going to about reach the hour mark. And, I've been trying not to go so long. But as you can see, okay, we'll almost be done. Then after that, it goes into contracts with the treaty, section, procedural information, contracting the treaty section, functions of the treaty section, delivery of documents, translations, the process on how it happens. All right, yeah, so, all right, verbal notes, legal counsel, all right, so that goes into a whole nother science right there. But okay, we're gonna end off on publication.
5.4.2. 5.7.4 Publication. See the Repertory of Practice, Article 102, paras 82 to 107, and Articles 12 to 14 of the regulations in the Annex to the General Survey. Monthly Statement. See the Repertory of Practice, Article 102, and Articles 13 to 14 of the regulations in the Annex to the General Survey. Each month, the Secretariat publishes a statement of the treaties and international agreements registered, or filed and recorded during the preceding month. See Article 13 of the regulations. The monthly statement does not contain the texts of treaties or international agreements, but provides certain attributes, in English and French, of the treaties or international agreements registered or filed and recorded, such as the A. Registration number or filing and recording number. B. Title of the instrument. C. Names of the parties between whom it was concluded. D. Date and place of conclusion. E. Date and method of entry into force. F. Existence of any attachments, including reservations and declarations. G. Languages in which it was drawn up. H. Name of the party or specialized agency registering the instrument or submitting it for filing and recording, and I. Date of registration or filing and recording. The monthly statement is divided into two parts. Part 1 lists the treaties registered. Part 2 lists the treaties filed and recorded. In addition, the monthly statement contains Annexes A, B, and C. Annexes A and B are devoted to certified statements, example, ratifications or accessions, and subsequent agreements relating to treaties or international agreements registered or filed and recorded. Annex C lists subsequent actions relating to treaties or international agreements registered with the League of Nations. United Nations Treaty Series Article 12 of the regulations provides that the Secretariat shall publish as soon as possible, in a single series, every treaty or international agreement that is registered or filed and recorded. Treaties are published in the United Nations Treaty Series in their authentic languages, followed by translations in English and French as required. Subsequent actions are published in the same manner. The Secretariat requires clear copies of treaties and international agreements for publication purposes. Registering or filing and recording treaties 5.35. Limited publication. Originally, Article 12 of the regulations required the Secretariat to publish in full all treaties and international agreements registered or filed and recorded with the Secretariat. The General Assembly modified this framework in its Resolution 33-141 of December 19, 1978 in light of the substantial increase in treaty making on the international plane and the publication backlog that existed at that time. Report of the Secretary-General, Document A/33/258, October 2, 1978, paras 3-7. According to Article 12(2) of the regulations, as amended in 1978, the Secretariat is no longer required to publish in extenso, i.e., in full, bilateral treaties falling within one of the following categories. A. Assistance and cooperation agreements of limited scope concerning financial, commercial, administrative, or technical matters. B. Agreements relating to the organization of conferences, seminars, or meetings. C. Agreements that are to be published otherwise than in the United Nations Treaty Series, by the United Nations Secretariat, or by a specialized or related agency. The publication backlog continued to grow, however, and in 1996 stood at 11 years, i.e., an instrument registered in 1987 was scheduled to be published by 1998. This backlog has been reduced to approximately 2.5 years as at 2001. As a result, in 1997, the General Assembly extended the limited publication policy to multilateral treaties, so that the Secretariat now has discretion not to publish in extenso bilateral and multilateral treaties, or agreements falling within one of the categories listed under Article 12(2)(a)(2)(c), General Assembly Resolution A/RES/52/153 of December 15, 1997. The General Assembly 7. Invites the Secretary-General to apply the provisions of Article 12, Paragraph 2, of the regulations to give effect to Article 102 of the Charter of the United Nations to multilateral treaties falling within the terms of Article 12, Paragraph 2(a)(2).
So in other words, that sounds like they're not responsible to do your publication, or like you have your meetings and all that stuff and Kind of like you gotta do that part of yourself on your own. But however, when you do register and all that, afterwards they're gonna have a conference where you sit down and basically make this a publication before the world, and have your UN conference and all that good stuff. You know what I'm saying? So yeah.
2C. Lengthy lists of products attached to bilateral or multilateral trade agreements also fall within the limited publication policy. In addition,
yeah. So in other words, you can't have like 1,001 documents attached to your So understand these provisions and all the articles they're giving you, like the Article 12 regulations, da 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 da. You basically state these same regulations and all that, and unless you have other documents you add in, but you don't have too much stuff attached to it, basically. And limited publication, basically.
Addition, agreements of the European Union are published only in English and French. Today, approximately 25% of the treaties registered.
And the reason why they do it in English and French, because French is the original language of the UPU, what I'm saying, and and all of that, the Berne Conference and the Berne Constitution and Treaty of Berne and all that good stuff is all in French and everything like that.
Registered are subject to the limited publication policy. An example of a multilateral treaty or agreement falling under the extended scope of Article 12(2) is the agreement concerning the adoption of uniform technical prescriptions for wheeled vehicles, equipment, and parts which can be fitted and or be used on wheeled vehicles, and the conditions for reciprocal. In determining whether or not a treaty or international agreement should be published in extenso, the Secretariat is guided by the letter and spirit of the Charter of the United Nations and Article 12(3) of the regulations. The primary criterion in making this determination is the requirement that the Secretariat shall 5. Registering or filing and recording treaties. 36. Duly take into account, inter alia, the practical value that might accrue from an extenso publication. Under Article 12(3) of the regulations, the Secretariat may reverse a decision not to publish in extenso at any time. Where the Secretariat exercises the limited publication option in relation to treaties or international agreements registered or filed and recorded, their publication is limited to the following information in accordance with Article 12(5) of the regulations. A. Registration number or filing and recording number. B. Title of the instrument. C. Names of the parties between whom it was concluded. D. Date and place of conclusion. E. Date and method of entry into force. F. Duration of the treaty or international agreement, where appropriate. G. Languages in which it was concluded. H. Name of the party or specialized agency registering the instrument or submitting it for filing and recording. I. Date of registration or filing and recording, and J, where appropriate, reference to publications in which the complete text of the treaty or international agreement is reproduced. Treaties and international agreements that the Secretariat does not publish in extenso are identified as such in the monthly statement with an asterisk. 6. Contacts with the treaty section. Procedural information. 6.1 General information. 6.1.1 Contacting the treaty section. Treaty Section, Office of Legal Affairs, United Nations, New York, New York, 10017 USA. Telephone, +1 212 963 5047. Facsimile, +1 212 963 3693. Email, generaltreaty@un.org. Registration, treaty registration @un.org. Website, http://untreaty.un.org.
So yeah, basically that's the information for the Office of Legal Affairs in the United Nations. That's located in New York. That's their telephone number, their fax number, their email. So if you want to contact them, you have questions or whatever, you can contact them through their email, and you can send your registrations, your treaty registrations through their treaty registration at un.org, their website right here. You know what I mean? And so forth, so forth. So let's click on this real fast. Okay, no permission. All right, let's go back. All right, so anyway, yeah, we on the hour mark anyway, so I'm end this off. So it's another episode of Universal Temple. You know what I'm saying? We just delved into treaties and how you register your treaty and everything you got to do, date of entry, all that good stuff, publication name, you seen all the stuff they went through, A through J, whatever, all that good stuff you had to have in your documentation and so forth. So I'm just here to bring y'all this information. This is what I need help with, y'all. I'm doing all this by myself right now. So y'all see what I'm dealing with, all the stuff that needs to be done. This is why I'm like, yo, where the gods at, where the earth's at. Can't do all this by myself, man. Damn. Shit is a lot. Don't y'all see all this, man? Ain't nobody going to assist. Nobody going to lend a God a helping hand. Oh, go ahead, God, do all that self. I brother be saying, yeah, God, you got to do it by yourself, God. You got to show and prove, and then we going to add on. No, I need y'all to add on now. Y'all see all the stuff that needs to be done? Like, I need y'all to add on now, not later. after I freaking go gray doing all this damn paperwork. But anyway, peace. I'll see y'all in the next episode, y'all. Peace. Just happened. Peace, y'all. Okay. Okay, so fucking end it, man. Come on, man. Peace, y'all. See y'all next session. Peace.